Welcome back, everyone. As I said at the beginning, the second half is going to focus more on the practical realities of litigating class actions. So we're going to kick off with a session on group litigation orders. Simon Salzedo and Joe Box. Simon is going to give an overview of GLOs, and then Joe is going to focus in particular on GLOs from a defendant's perspective. So Simon.
Afternoon. It's lovely to see so many people. As I'm sure probably you all know, we had to turn the programme round. So this talk was supposed to be right at the start when there would have been much fewer people. And that's because in a really interesting day's programme, this is basically the real policy justification is sort of policing defendants who might otherwise conduct themselves in ways that society wishes to prevent, but where there is no other good mechanism of preventing it. If we think that's a really good idea, maybe we want to expand opt-out actions rather than just opt-in. On the other hand, if we maintain the sort of pride that the UK is not the full litigation culture of the US, maybe the big increase in the use of GLOs might lead to some kind of swing back, although if the US is anything to go by, there is no swing back anywhere near any horizon any of us can see. Thank you.
Thanks, Simon. So this afternoon, having had the sort of overview from Simon about how GLOs work generally, I'm going to look at it from the perspective of the defendant. When acting for defendants in group litigation, I'm normally asked quite early on to advise on whether or not a GLO is in the defendant's interest. And so what I'm going to do is discuss the advantages and disadvantages specifically for a defendant, and then come on to discuss how defendants can resist in order for a GLO. So the first advantage of a GLO for a defendant is the imposition of an orderly structure with lead solicitors. Large numbers of different law firms representing different claimants or claimant groups can pose a real headache for a defendant. It brings a high volume of correspondence and potentially claims proceeding in multiple different courts. Having a GLO will not only bring all of the claims into one process, but it will usually also result in one set of lead solicitors, or if there's more than one set, at least some sort of ordered structure. The claimants will only be entitled to instruct one counsel team. The selection of lead solicitors is unsurprisingly often itself a source of dispute, though this is generally more of a problem for the claimants themselves than it is for a defendant. The courts have been pretty robust in relation to applications to add further lead solicitors. For example, in Hudson and Tata Steel, Mr. Justice Turner, back in 2017, dismissed an application for another firm to be added as a lead. He said that the new firm were going to have to demonstrate that their appointment would enhance the achievement of the overriding objective. In the case, he concluded that adding another set of lead solicitors was going to be counterproductive and more likely to produce what he described as a long-running forensic Punch and Judy show. Inevitably, an additional firm was going to increase costs and demands upon the court's resources. And in that particular case, there was actually already an ongoing dispute between the different claimant firms as to how the case should be managed. The courts have also been robust on the cost consequences of these disputes in relation to lead solicitors. In the VW emissions litigation, the defendants got costs on an indemnity basis, where hearings were adjourned following a dispute between the lead solicitors. In my view, the need to have lead solicitors is actually a real advantage of a GLO for defendants. It can significantly reduce the burden on the defendant, and it makes it a lot easier to manage the litigation. The other major advantage of a GLO for a defendant is the cut-off date. After the cut-off date, claimants can no longer be entered onto the group register without the court's permission, and this, at least in theory, limits the number of claimants who can join the litigation. Claimants usually ask for a later cut-off date to have the best chance of attracting the maximum number of claims, and defendants will normally seek a shorter cut-off date to limit the potential claimant pool and so that they know what their maximum exposure is likely to be earlier in the process. a claim can still proceed even if it's issued outside the GLO proceedings or after the cut-off date, but generally a defendant can get that claim stayed. If a claimant wants to join the GLO register after the date, then the test for relief from sanctions applies, and the court will take into account factors like why an application wasn't made before the deadline and what impact it will have on the court timetable. The cut-off date itself could be another source of litigation. In the BA data group litigation, the parties had originally agreed a cut-off date and then an extension by consent. The claimants later applied to extend it until approximately 1 year after the proposed liability trial, and they gave evidence that only about 5% of eligible claimants had come forward, and that approximately 3,000 claimants were coming forward every week, and that was expected to continue. Notwithstanding that evidence, the court said that there did have to be a deadline and extended it by only 2 months. So it is a useful tool for defendants to be able to have that cut-off. However, there are also inevitably disadvantages for a defendant. The most obvious one, as Simon mentioned, is publicity. CPR 19 provides that the GLO may give directions in relation to publicity. There isn't any real guidance on what that publicity should look like or who should pay for it, and there's nothing on this in the practice direction. Usually, publicity will be done by the claimant firms, but occasionally a defendant might actually be ordered to assist. So, for example, in Arif and Berkeley Burke, the court ordered the defendant to write to all of the investors connected with the particular investment to alert them to both the existence of the GLO and the cut-off date. However, those are quite unusual circumstances. The defendant in that case had already sent an FAQ document to investors, which the claimants argued cut across the process of publicity, which the court had endorsed. And more recently, in Edward Moon and Link Fund Solutions, the court refused a similar order. In that case, Mr. Justice Trower emphasised that it's not the purpose of a GLO to encourage claimants to make claims, nor should the court be ordering anyone to invite shareholders to join group litigation. And the judge there was particularly concerned that the simple fact of the court making an order that the defendants publicise the GLO would be likely to be read as an encouragement from the court to pursue those claims. So I think it's reasonably unlikely that there'll be lots of cases where defendants themselves have to engage in publicity, but even just the publicity by claimant firms endorsed by the court is generally going to be something that's quite unhelpful as a defendant. The second potential disadvantage is several liability for costs. The default in a GLO is several liability for common costs. However, this may not make much difference in practice if there's a funder against whom costs can be sought. And costs and funding is something that Simon is going to come on to talk about later, Simon Birt. In any event, it's increasingly common for claimants to seek the same order in group litigation regardless of whether there's a GLO. And in my experience, it's actually quite difficult as a defendant to resist that. There aren't any particularly good reasons in group litigation that defendants can give against several liability for common costs. So whether or not there's a GLO, that tends to be the order that's now made. The third disadvantage to note is the level of oversight and case management that you get with a GLO. So along with a managing judge, a GLO will often bring an additional level of court scrutiny and oversight to proceedings, which a defendant may or may not consider to be advantageous, depending on the nature of the claims. For example, in Bates and Post Office, after expressing some concerns about the approach to the litigation to date, in the first common issues judgment, Mr. Justice Fraser announced that until the litigation was resolved, he intended to hold substantive trials in tranches every single judicial term from November 2019 onwards into the future. Now, that sort of order is not ideal for most defendants, and in my view, it's pretty unlikely that you'd ever get something like that outside of a GLO. If, having thought about the advantages and disadvantages for your case, as a defendant you want to resist a GLO, there are several things to think about in terms of how to best achieve that. And there are a number of different options to take. First, a defendant can dispute the existence of common or related issues of fact or law. In particular, if a defendant can show that each claim requires proof of individual circumstances or claimant-specific factors, then that's something that can be said will actually undermine the efficiency of having a GLO in the first place. It's not always enough. In Chew and Bank of Scotland, notwithstanding the importance of some individual factors, in particular that were relevant to the test for unfairness there, the court nonetheless did order a GLO. But it's an important factor to point to. The second option for a defendant is simply to say that there are other better ways to manage the litigation. And this was another point that was considered in Edward Moon by Mr. Justice Trower last year. In that case, the defendant argued that actually all of the desirable aspects of a GLO could be achieved through conventional case management techniques, such as generic pleadings, orders for cost sharing, and a trial of test cases, and that there was no need there to have a group register or lead solicitors. The defendant was able to point to other examples in the financial world where the court could use its case management powers without a GLO. And in particular, a lot of emphasis was put on Ingenious, litigation in which I was instructed, where there wasn't a GLO, but there was a managing judge from very early on. There were generic particulars of claim produced by the three law firms together. And a lot of the efficiencies that you might get in a GLO were actually achieved without making that order. The obvious alternatives, if you aren't going to have a GLO, are either lead claimants or a trial of preliminary issues. And I think it's really important as a defendant to think about which of those better suits your case. If as a defendant your case is stronger on the claimant-specific factors, such as reliance or causation, then it's much better to have lead claimants. And the last thing you want is a lengthy preliminary issues trial, which is going to lead to a bunch of adverse findings on common issues. I think following cases like Edward Moon, it will be easier to persuade the court that a GLO isn't needed. And the courts are willing to pick and choose those elements of the GLO process which best suit a case. However, I think the most important point for a defendant to take away is that you have to think about these issues very early in the pre-action correspondence, because the key is to try and position yourself to best get the sort of case management you want. If that's a GLO, it's something to raise very early on. But if it's not a GLO, it helps if you're proactively suggesting alternatives and to make it clear that that's how you think the litigation can sensibly be managed. I think that's probably enough on GLOs from us, but thank you very much for listening.
Thank you, Simon and Joe. Can I just check if anyone has a question on GLOs or even a joke to rival Simon's?
Wasn't mine.
No, all right, you're free to go. Thank you very much. Thanks. In which case we'll move on to representative actions, Gerard Rothschild and Jaamae Hafeez-Baig. Yeah, do you mind? We'll just get some help with you. Just whilst they're putting their microphones on, to explain, Gerard is going to explore the same interest requirement as was explained by the Supreme Court in Lloyd and Google, but has been applied, I think, on 2 occasions this year. There have been some recent cases. And then Jaamae is going to address 2 particular questions about representative actions that remain unanswered post Lloyd and Google. Firstly, the effect that commencing a representative action has on limitation periods. And secondly, the rights, if any, that a litigation funder might have in relation to the proceeds, which I'm sure will be a topic of interest to some in the audience. Gerard, when you're ready.
Well, thank you, Tony, for that introduction. Lord Leggett said this in Lloyd and Google, a case that Victoria started to tell us about earlier today. He said, only one condition must be satisfied before a representative claim may be begun or allowed to continue. That is, that the representative has the same interest in the claim as the persons represented. All true, but it is beguilingly simple. So I'm going to consider the origins of the same interest requirement, how the Supreme Court dealt with the requirement in 2021 in the key modern case on representative actions, Lloyd and Google, and then 2 first instance judgments of earlier this year which sought to apply the requirement. One is rather generous to class actions and the other not so. Well, representative actions are, on any account, of ancient pedigree. They have their origins in the flexible practice of the Court of Chancery in the 16th and 17th centuries. So whereas the ordinary courts of law required all parties to be present before them in order to be bound, the courts of equity could give rulings affecting those who were not present before the court, just so long as there was some commonality of interest. And so when the Royal Society of Arts, which has its home in this magnificent building, was founded in 1754, the representative actions procedure was already very well established. And indeed, the same interest wording which is now in CPR 19.8 can be traced back to the very first iteration of the rules of the Supreme Court. Here on the slide, you'll see on the left of the screen, the first rules of the Supreme Court, 1883, the version in force when the founder of Birt Court Chambers, William Jowett, was born in 1885. Order 16, Rule 9, you'll see the text there, and you'll see same interest wording, which is also there on the right-hand side, the modern CPR 19.8. All of you will see the similarity. And by the way, in case you're confused by the numbering, 19.8 was until earlier this year 19.6 when the Rules Committee did some tidying up. So what does same interest mean? That was the issue in Lloyd and Google. Victoria touched on the case earlier, but I'll elaborate a little on the facts. So in that case, citation on the screen, Mr. Lloyd sought to use the representative action procedure for a very large class action. He wanted to claim against Google on behalf of over 4 million UK resident iPhone users, alleging that their internet activity was being secretly tracked by Google for commercial purposes. And he relied, as Victoria told us, on Section 13.1 of the Data Protection Act 1998, now superseded, but which back then provided a right of compensation where an individual, quote, suffers damage by reason of any contravention by a data controller of any of the requirements of the 1998 Act. So Mr. Lloyd wanted permission to serve the claim out of the jurisdiction, and so he needed to show a real prospect of success in order to proceed. And there was no doubt that Mr. Lloyd himself had a claim for substantial damages. The issue was, did he have the same interest as the others he sought to represent? Well, he argued for an equal standard tariff award of damages for each class member. In other words, that everyone had the same lowest common denominator monetary claim. And the Supreme Court unanimously held the claim failed. As Victoria told us, the wrong which was sued for required the claimant to prove material damage or distress and the extent of unlawful processing in the individual's case. But being the Supreme Court in 2021, an opportunity was taken to give a more general analysis of the very interesting area of law. And it's the, well, entirely obiter comments of Lord Leggett giving the judgment of the court on what amounts to the same interest that I'd like to focus on. Well, essentially, Lord Leggett recognises the practicality of the representative actions regime for bringing class actions and is very supportive of expanding its use. The key passage is paragraphs 67 to 74, where Lord Leggett endorses the view that CPR 19.8 is, and I quote, a flexible tool of convenience in the administration of justice. And he says, applied to the exigencies of modern life as occasion requires. He explains the phrase same interests needs to be interpreted purposively in light of the overriding objective of the CPR and the rationale for the representative procedure. Well, purposive interpretation obviously involves identifying the purpose. What is it? Well, he explained the purpose of requiring the representative to have the same interest in the claim as the persons represented is to ensure the representative can be relied on to conduct the litigation in a way which will effectively promote and protect the interests of all the members of the represented class, which he said was plainly not possible where there is a conflict of interest between class members, and that an argument which would advance the cause of some class members would prejudice the position of others. So whether there is a conflict of interest is key. However, conflicting interests need to be distinguished from merely divergent interests, and therein is the complexity. And thus the scene was set for judgments of the lower courts, applying the newly declared position to ambitious large-scale class actions. Well, there have not been many, but I want to focus on two from earlier this year, and the first citation on screen is Commission Recovery and Marks and Clark, a judgment of Mr. Justice Robin Knowles. Well, Marks and Clark are patent and trademark attorneys, and it was alleged that they'd received undisclosed commission for renewing IP rights. And the claimant company was set up for the specific purpose of bringing a representative action on an opt-out basis on behalf of all of the current and former clients of Marks and Clark to recover that commission, a large class. But of course, the circumstances of each class member differed very greatly. There may well have been different terms of contract, different commission payments. Some claims might have been time-barred. Some of the claimants might actually have preferred a proprietary claim over a personal one. So potentially a pretty wide variety of factual scenarios, which could well, for example, benefit from disclosure by the individuals rather than the representative. So did they have the same interest in the claim under the Lloyd and Google test? Well, the answer Mr. Justice Robin Knowles gave was that there were differences, indeed very significant differences, but they were not conflicts. They were, in his words, points that need not prejudice the interests of some clients at the expense of others, the classic test for conflict of interest. So he held that the success or recovery by one client would not prejudice the interests of another. And so he held there was no absence of same interests and there was jurisdiction for a representative action under what is now 19.8. But even where there's jurisdiction, the court also has a discretion in an unwieldy case, and more generally under CPR 19.8, not to allow a representative action to proceed. So unlike with a GLO, where you need the court's permission just to get it off the ground, with a representative action, you can start it, and then it's only if the other side or the court of its own initiative raises the point that the discretion comes into play. Well, in Marks and Clark, the judge expressly recognised that it would be necessary to place reliance on the claimant to pursue vigorously, his words, lines of argument that were not directly applicable to the representative's individual case. Now, that seems to me to come very close to saying that the representative might not be incentivised to actually promote and protect the interests of all of the class members. But nevertheless, on discretion, Mr. Justice Knowles was pragmatic. He said, and I quote, "If the choice is this or nothing," meaning 19.8 or nothing, "then better this." And then there's an uncharacteristic endnote in his judgment, a judicial plea for a flexible use of CPR 19.8. He notes, and I quote, "In a complex world, the demand for legal systems to offer means of collective redress will increase, not reduce." Well, it could well be a subtitle for today's seminar. But in short, a generous, expansive scope given to representative actions by a judge who's clearly a proponent of class actions. Well, the second case of earlier this year that I want to cover is Prismal and Google, citation on the screen, a judgment of Mrs. Justice Heather Williams. Victoria touched on it, but didn't give you any details. The case concerned alleged misuse of the private information of a class of some 1.6 million people. They were patients of the Royal Free Hospital whose information had been passed to Google DeepMind without the patient's consent for the purposes of an app to be used by clinicians on their smartphones to identify cases of acute kidney injury. Now, Andrew Prismal was one of those patients, and he sought to represent the class and to claim loss of control damages for all of the class members. And the basis of this was said to be that there was a lowest common denominator loss suffered by all members of the class. So he argued that all medical information, whatever its form, is private, and its control has value. And therefore it could be said that all members of the represented class had the same bare minimum damages claim. Well, the end result was the judge struck out the claim because she considered that the lowest common denominator was 0 on the basis of evidence from the defendants that some of the class, as defined, would have lost only negligible or insignificant data. They might not have cared about control over their data. She said they might even have publicised it themselves. And so therefore it could not be said that there was a lowest common denominator greater than 0. It couldn't be said of any given class member that he or she had a viable claim with a reasonable prospect of success, and that is crucial to claim damages on a lowest common denominator basis. That much is conventional, but the judgment then went a bit further, because the judge did not even allow the representative claimant an opportunity to amend his case to narrow the class so that the lowest common denominator was increased to greater than 0. It seems fairly obvious, to me at least, that the class could have been narrowed, for example, to include only those for whom the Royal Free Hospital held embarrassing medical information, which on no view anyone would have shared. publicly of their own accord. But nevertheless, the judge struck out the claim with no opportunity to amend. So I'd say an example of a judge who, unlike Mr. Justice Knowles, was sceptical, unsympathetic towards a representative action. So I note in passing, for the interest of those here who might have been treated at the Royal Free Hospital in the relevant period and are now time-barred from bringing their own privacy breach claims, that Google, against Google, that there is a chance that the prismal representative action might go further. There's a pending application for permission to appeal Mrs. Justice Williams' judgment to the Court of Appeal, focusing on whether the judge applied privacy law appropriately. But in any event, the case will remain an illustration that the same interest test is relatively simple to state, but it contains traps for the unwary. So in short, more work for the lawyers. Over to Jaamae.
Thanks very much, Gerard. So the Supreme Court in Lloyd and Google settled a number of controversies about the same interest requirement, but there are a number of unresolved issues that remain, and I want to talk about two. The first, decidedly less interesting but no less important, is about limitation, and the second is about litigation funding. And Simon and Charlotte will then return to litigation funding, including the Supreme Court's decision in Packard later on. So the first question is this: what effect does commencing a representative action have on the limitation of the group members' claims? Does it stop the limitation clock running for those claims, or does the limitation clock continue? And this question will arise in any case where a bifurcated process is adopted, that is, where the representative claim resolves certain issues that are common to all the group members, but leaves other individual issues for later determination. Once the common issues have been decided, and the group members either commence their own proceedings or apply to be joined to the proceedings, will their limitation clocks stop from that date, or did they stop at the date the representative action commenced? And I'll put that into a more concrete example. So suppose that a representative action seeks a declaration that the group members are entitled to damages for any loss they've suffered as a result of a particular act by a particular defendant. If that claim succeeds, and the court makes that declaration, the group members will then come forward to individually prove their loss and establish their entitlement to damages in a particular amount. And when it comes time for them to do that, they might find that their claims are time-barred if the limitation clock didn't stop when the representative action was first commenced. And given Lord Legate's evident enthusiasm for the bifurcated process in Lloyd and Google, we can expect this issue to arise sooner rather than later. Indeed, it probably would have arisen in Lloyd and Google if a bifurcated process had been used, given that Mr. Lloyd filed the representative action close to the end of the limitation period. The issue will also arise if any group member decides to opt out and pursue their own claim. If the limitation clock didn't stop when the representative action commenced, they might then find their own claim to be time-barred. In modern class action regimes, this issue is generally dealt with by statute. So to give one example, the Australian federal class actions regime has a simple section which says, on the commencement of a representative proceeding, the running of any limitation period that applies to the claim of a group member to which the proceeding relates is suspended. And there's a similar but more detailed provision in the collective proceedings regime in the Competition Act in this jurisdiction. But there's no such provision in CPR 19.8. So we're left with the case law. And when we look at the cases, we find, as we often do, that the English authorities are conflicting. On the one hand, there are some obiter statements in old Court of Appeal authority and in more recent first instance authority that suggest that where the representative action is only seeking determination of some common issues, the limitation period continues to run as against the group members. On the other hand, there's more recent Court of Appeal authority which says that where the representative claimant settles or withdraws from the action, then a group member can be substituted to prosecute that same representative claim in their place on the basis that for that group member, the limitation period stopped back when the representative action was commenced. As a matter of principle, I think there are at least two ways of looking at this problem. The first way is to ask whether the group members are parties to the representative action. And you can find various answers to that question in the case law. But to my mind, that's the wrong question to ask, not least because the answer might differ depending on the purpose for which you're asking the question. It's also not the question which is posed by the Limitation Act itself. And that brings me to the second way of looking at the problem, which is to notice that the Limitation Act prohibits actions from being brought. And so the second way is to ask whether group members brought an action when the representative proceeding was commenced by the representative claimant. This is the way the question's been addressed in Australia and in New Zealand, and in both jurisdictions the conclusion that's been reached is that the limitation clock did stop for all group members when the representative action was commenced. And the basis for that conclusion was that when the action was commenced, the representative claimant brought an action on behalf of all of the group members. That seems to also be the position in the United States, and in Lloyd and Google itself, Lord Leggett suggested that this might be the correct approach, but didn't decide the issue. The answer might also, I think, depend in part on how the second stage of the bifurcated process is set up. If it's structured in such a way that, that will involve the individual group members resolving their individual issues in fresh proceedings after the determination of the representative action, then they might find their claims to be time-barred. That would seem to be a fresh action which would be barred by that time by the Limitation Act. But if it is structured in a way which allows them to resolve those individual issues within the confines of the original representative action proceeding, the same issue doesn't seem to arise. So given the broad discretion that trial judges have in determining the process to be adopted in representative actions, which Lord Leggett himself confirmed in Lloyd and Google, it's important to bear in mind the potential limitation consequences when designing the procedure. Finally, on limitation, there's an issue which Lord Leggett didn't advert to, which is what happens when a representative action is improperly or invalidly constituted. But that only becomes clear after the limitation period has expired. And Lord and Google is a neat example of this. By the time the Supreme Court told us that it shouldn't have and couldn't proceed as a representative action, all of the group members were out of time. And so if anyone decided to commence their own proceedings today, there'd be a real question as to whether they were out of time or the limitation clock stopped back when the invalid representative action was commenced. To my knowledge, there's no English authority on this question. There is intermediate appellate authority in Australia, and in that case, the decision was that the limitation clock had stopped when the representative action was commenced, despite the fact that it was inappropriately used. And the reasoning for this was that the proceedings were an irregularity but not a nullity as regards their purportedly representative nature. And the Court of Appeal relied on the equivalent of CPR 3.10, which says that where there's been an error of procedure, such as a failure to comply with a rule, the error does not invalidate any step taken in the proceeding unless the court so orders. But once again, we need to be careful about the procedural context, because in that case, the issue is whether the group members should be allowed to join the representative action proceedings at a time when the limitation period otherwise would have expired. That arguably seems to be different to a case where the group members start fresh proceedings. In that type of case, the action does, on its face, seem to be barred by the Limitation Act. And that would seem to be the position for the group members in Lloyd and Google today. And that's certainly something to keep in mind. That takes me through to the second and more interesting question, which is about litigation funding. The question is this: how, if at all, can a litigation funder recover any share of the proceeds of one of these representative actions? And this would have become an issue in Lloyd and Google if the Supreme Court had gone the other way and told us that the representative action procedure had been properly invoked. The proposal in that case was that the litigation funder would have a first claim on the proceeds of the action, but the basis for any claim, if there is one, is unclear. Lord Leggett didn't address the issue other than to say that it would be a question of considerable difficulty whether there is any legal basis for paying a share of the damages to the litigation funder. The starting position, I think, must be that each group member has a claim for a certain amount of damages. They have a legal right to that amount of damages. And if that right is to be cut down by giving the funder a share of that recovery, there must be some legal basis for it. And I think there are at least four possible bases. The first and most obvious is contract. There's nothing prohibiting litigation funders from going out and entering into litigation funding agreements with some or most of the group members in the process we call book building. But as we've heard this morning, it's a costly and time-consuming process and not always feasible. The second possible basis is statute. There might be a statutory provision authorising the funder to take a share of the proceeds, or authorising a court to authorise the funder to take a share of the proceeds. But there's currently no such provision in this jurisdiction, at least outside the competition context. The third basis is what are sometimes called funding equalisation orders. And these are quite an old creation. They were orders developed by the Court of Chancery in response to a situation where you had a representative action, but the solicitors had only entered into a costs agreement with the representative claimant. And so the Court of Chancery adjusted the rights of all the parties to ensure that the costs and expenses incurred by the representative claimant would be borne pro rata by all the members of the group. And so the order allows the representative claimant to deduct their costs and expenses from the fund before it is distributed to the group. And so in this way, each of the persons who benefits from the group litigation is required to contribute pro rata to its costs and expenses. And the rationale for that sort of order, you can see, is essentially restitutionary. If X has created, preserved, or increased a fund in which others have an interest, then X is entitled to be reimbursed their fees from that fund before it is distributed. Otherwise, those other people with the interest in the fund are unjustly enriched at the expense of X. There's old House of Lords authority from the late 1800s in support of this approach, and to me there doesn't seem to be any reason why it couldn't be applied to the costs and expenses that a representative claimant incurs in obtaining litigation funding for a representative action. But it doesn't seem to have been deployed in that way so far. The fourth and final basis is what are sometimes known as common fund orders. These orders have been much considered in the Australian jurisprudence, including in 2019 by the High Court of Australia in BMW and Brewster. And this essentially is an order which allows a litigation funder a share of the proceeds of the action, as if the litigation funder had entered into a funding agreement, with each member of the group. And the key difference between a common fund order and a funding equalisation order is that a funding equalisation order doesn't increase the overall amount payable to the litigation funder. The litigation funder is entitled to whatever it is they agreed with the lead claimant they'd be allowed to receive. All it does is share that cost across the group, hence the name funding equalisation order. A common fund order, however, has the potential to increase the amount payable to the funder because it involves each group member being required to give a share of their proceeds to the litigation funder. But the difficulty with this sort of order, as you'll probably appreciate, is that it requires clear statutory authorisation. That was the issue in Brewster, which the High Court was dealing with. And the provision in that case was very broad. This was in the context of their generic class actions regime. But the provision allowed the court to make any order that the court thinks appropriate or necessary to ensure that justice is done in the proceeding. And despite the obvious breadth of that order, the majority of the court held that it didn't authorise a common fund order. So to summarise, there's a very real question about whether litigation funders have any right to a share of the proceeds of representative actions, and if so, the basis for that right. Lloyd and Google didn't give us an answer, but Lord Leggett did make some, it would seem, negative comments about the issue. But in any event, given the importance, I'm sure it'll be decided sooner rather than later. Thank you.
Thank you very much, Jaamae. Does anyone have any questions about representative actions? If not, I think we'll move on to our next session, which is funding and costs. So Simon Birt and Charlotte Thomas will speak about funding and costs. I'll just come and help you put your microphone on. Just to explain, Simon was involved in the ingenious litigation for many years, and he will discuss some of the costs issues that arise in group litigation, including how costs are apportioned as between groups of claimants, and also the question of obtaining security for costs against funders. And then Charlotte will pick up more recent developments, the Packard judgment in particular, and how things have moved on in the months since we've had the Supreme Court's decision.
Afternoon, everybody. Cost is, of course, in some ways at the heart of the concept of group actions. It's generally when the costs of pursuing an individual's claim are too high if pursued on its own, but would be more manageable if pursued collectively with other similar claims, that a group action comes to be chosen as the vehicle for the pursuit of the claims. It's the sharing of the costs that makes the group action feasible. Of course, many, if not most, group actions are supported by litigation funding to cover the claimant group's own costs, and by ATE insurance or similar to deal with adverse costs awarded to the defendants. However, as a number of recent cases have shown, even where both of those are in place, that doesn't necessarily mean that costs become irrelevant to the individual claimant, or that the parties cannot find plenty to fight about at the interlocutory stages relating to costs. Now, in the time available, I'm just going to make some brief comments in relation to three general topics. First is the claimant's responsibility for their own costs. Second is the claimant's liability for adverse costs. And third, some brief points about security for costs. So first, in relation to the claimant's responsibility for their own costs. As Mr. Justice Hilliard said in the RBS litigation a few years ago now, cost sharing is a fundamental feature and advantage of a GLO. And how the claimants share their own costs is, of course, at least at the outset, a matter for agreement between the claimants themselves. And if sufficient litigation funding is in place for all claimants, how costs are ultimately shared may be of limited immediate interest. But there may be some situations where there's a concern that funding may run out, or it may be that some claimants choose to self-fund their claim within the context of a group action where the majority are funded. And that's what happened in the Ingenious group litigation that I was involved in. A significant number of the claimants, in fact, some of those with the highest value individual claims, were self-funders. And beyond that, there may be issues that arise in cases with different claimant cohorts, where, for example, different claimant groups represented by different firms of solicitors, they may not agree on how costs should be split. Or to give an example, another which has arisen recently in a couple of cases, in a case where a GLO is in place, existing members of a group may seek to impose a regime that they have agreed as to cost sharing on later joiners to the claimant register. The question has arisen whether the existing claimants can obtain an order effectively forcing subsequent joiners to the register to join only on the terms as the cost sharing that the existing claimants have already reached. Now, the courts have generally shown, to date at least, a reluctance to make that sort of order, generally being unwilling to impose on future parties a particular form of agreement. There may be some clever ways of doing it, and some of Jaamae's examples might be, that he just gave us, maybe the sort of things that might be used. And in any event, the gist of the judgments of the courts will be unwilling to allow any of the claimants to join up only for a free ride. So, for example, in Cavallari and Mercedes-Benz, the senior master in the judgment which is available indicated that if a new joiner refused to sign up to the cost-sharing terms that have been agreed with everybody already, there would be scope for the existing claimants to seek a direction that the new joiner pay its share of the costs as it went along on what people refer to as a pay-as-you-go basis. So a court will do its best to ensure that all claimants are in roughly the same boat as regards their own costs. And as I say, it's seen as a fundamental part of group litigation that the price for seeking the reward of the benefits of a group claim is that costs are shared fairly. Second topic, and perhaps more interestingly, there is the claimant's liability for adverse costs. And there's the initial question whether that liability is likely to be joint or several. And as Jo mentioned when she was talking about group litigation orders, there is a default rule within the CPR, and that appears under Rule 46.6, that cost liability for adverse costs will, unless the court makes a different order, be several, as between the claimants relating to common issues and other matters in which they have a shared interest, such as the common administration of the claims. However, that, although a relatively simple and straightforward proposition of itself, conceals potentially difficult issues, not least in cases where there are subgroups of claimants, potentially different defendants that not all claimants sue. And I just wanted to pick up a small number of points that have arisen in some of the recent cases relating to that. First, the default rule in 46.6 applies where a GLO has been made, but what happens when no GLO has been made, but it's nonetheless group litigation in most senses. Joe's already slightly given you the answer to this, which is that it's likely that an order for several liability will be made, and there are a number of good reasons for that. We tried in Ingenious not to dissuade the court from making a several liability order, but to tell the judge that he had a real choice to make, so that when ordering several liability, he ought to almost order security for costs as a default, a sort of quid pro quo, but he didn't fall for that, unfortunately. He gave security anyway, but not on that basis. Mr. Justice Nugie's detailed judgment does go through some of the points, and amongst them he explains that there's no, in the absence of a GLO, there's no starting point that the claimants would all be jointly liable for all the costs. You can get cases, obviously, where you've got claimants bringing joint claims, and then the prima facie position may well be that they're jointly liable for costs. But that's not what we typically think of in relation to group litigation, when you've got a host of claimants bringing individual claims, albeit joined together for generally procedural reasons. So the approach is not one of starting with joint liability. It's basically the court has a wide discretion to decide what the most appropriate rule is to make, the most appropriate order is to make, taking everything into account. And in that case, he decided several liability, and I think that is most likely to follow in all group cases as a matter of likelihood. But second, once the court has decided that several liability applies, how should the liability be divided up? In what proportions? And there are various potential different candidates. Should it be divided per capita, which is part of the default rule under CPR 46.6, or should it be done on a different basis, such as in proportion to the size of each individual's investment, or the size of their claim, or some other basis? The answer given in Ingenious was pro rata according to the size of each individual's investment. And that was the same answer has been given a number of other cases, including by Mr. Justice Hilliard in the RBS group litigation. Now, in Ingenious, the judge saw actually there was a logic to making it the size of the claim rather than the size of the investment, but that's rather more practically complicated, particularly where you haven't got claims spelt out to the last pound and pence or dollar and cent. So the level of the investment is a good proxy. Either way, the per capita basis in this sort of group action, where you've got various different sizes of claim amongst the claimant cohort, was held in both those cases, both in RBS and Ingenious, not to be fair. There was a basic principle that the risks to a claimant of participating in the litigation should be proportionate to the reward that they might obtain from it. A third point to note about these sorts of orders made at this stage of litigation, a fairly early stage, trying to set out the parameters of adverse costs, is that the courts have been slightly wary of engaging in too much detail at too early a stage. Apart from making general statements of principle, they're quite often unwilling to sign off on very detailed structures as to which issues will end up being common issues and therefore susceptible to divvying up the costs, as opposed to claims associated only with a particular individual claim. The principal points have been made clear and set out in various cases, again including by Mr. Justice Nugie in Ingenious, such that you can say that all the claimants who are potentially interested in the part of the case on which the costs were incurred should bear an apportioned part of the liability for the defendant's costs insofar as they were common costs. But that's easier stated than applied in practice once you start to try and identify which issues are common to which claims, particularly where you've got claims brought against perhaps different defendants within the same litigation. Certainly in Ingenious, Nugie didn't want to go further than identifying those broad points of principle, and a similar reticence has been shown in other cases. In a recent judgment, Mrs. Justice Mulder in Upham against HSBC also didn't want to go beyond general statements of principle for similar reasons. And of course, as a matter of practicality, it might not ultimately matter if there is sufficient ATE in place or another common fund. But the risk for either defendants or claimants is that that fund it turns out not to be sufficient, which is why these points often end up being chased down as far as they can. And one last point to make about orders made at an early stage of the litigation about ultimate liability for costs is the extent to which those matters are then cast in stone for the duration of the litigation, or to what extent they might change. Courts often emphasise that they've got a discretion as to costs that they like to retain, and that the way that issues shape up during the litigation or develop during the trial may cause a court to think that costs ought to be treated differently than perhaps it appeared at the outset. So when a court has made that sort of framework order, to what extent does it retain its discretion? Mr. Justice Hilliard considered this in the RBS litigation, noting the tension between the competing objectives of certainty and flexibility. And his solution was to adopt the wording of CPR 3.197 in relation to a cost capping order, such that no variation would be permitted unless either A, there had been a material and substantial change of circumstances, or B, there was some other compelling reason for it. And that seems a reasonable sort of point to have arrived at the appropriate balance, and suspects it's generally going to be attractive to other courts. Then my third topic, very briefly, is security for costs. It was a point on which in the Ingenious litigation we went to the Court of Appeal, albeit only in relation to the question whether a defendant seeking security had to provide a cross-undertaking to the claimant or to the funder. The Court of Appeal's answer was not, or at least not except for exceptional cases. But in the first instance judgment of Mr. Justice Nugee, there's quite a lot of points about security for costs in funded cases more generally. And of course, you don't get it against the individual claimants, but you can usually get it against, or at least in principle, you can get it against a funder under 25.14. And the reasons put forward by the funder in Ingenious why security shouldn't be granted, because there was plenty of other sources that would eventually provide sufficient place for the defendant to go enforcing its costs order. There were the individual claimants, there was the funder itself, and there was ATE insurance. But Mr. Justice Nugee found that each of those three were inadequate on the facts. The problem with the individual claimants was that there wasn't sufficient evidence of their individual resources. And secondly, given the several liability order, a defendant would have to go chasing around hundreds of different claimants to try and make up each of the individual orders. And that was also a problem that Mr. Justice Hilliard had noted in RBS. The problem with the funder's own resources in Ingenious was that the funder was a Jersey cell that hadn't put in any information at all about its own financial position. And the judge held that simply the fact that it was a member of the Association of Litigation Funders wasn't sufficient to give enough confidence that ultimately they would pay a large liability for costs. And the problem with the ATE as a source was that it wasn't sufficient, and there are various holes in it, and there are various circumstances where it wouldn't respond. So as has happened in a number of other cases where ATE has been tendered as security, the judge accorded some weight to it, but reduced the overall value to put on it. So the result was there that security had to be put up additional to the ATE policies. In a sense, it ought not to have come to that. I mean, the Court of Appeal said in its judgment that a corporate litigation funder ought to be properly capitalised such that it ought to be able to defeat any application for security by showing that there's no reason to believe that it will be unable to meet an adverse costs order. And that undoubtedly will most usually be the case, one would have thought. But where it doesn't or cannot demonstrate that, then it is at risk of such an order. Having touched or started to touch on funding, I'm going to hand over now to Charlotte to talk some more about funding.
Thanks very much, Simon and Tony, and thank you all for not rushing for the door as soon as funding and costs appeared on the slide. I know drinks are close, but as Simon has said, this is a particularly important topic in the GLO or in the group litigation context, where funding is often necessary to get a case off the ground and is very important for access to justice purposes. And thus, at first instance in the PACAR case, which is what I'm going to talk about, including the implications of it, The Competition Appeal Tribunal was able to say that third-party litigation funding is a well-recognised feature of modern litigation that facilitates access to justice for those who otherwise may be unable to afford it. That obviously wasn't always the case, and in fact the blossoming of third-party litigation that we've seen in this jurisdiction has arisen only relatively recently. The criminal prohibition on maintenance and champity was lifted in 1967, and it was then the Courts and Legal Services Act of 1990 which introduced CFAs. They were then expanded in 1999, and a Court of Appeal decision reached in the famous Factortame litigation in 2002 concerning whether accountants could participate in a CFA, said that only those funding agreements meant to undermine the ends of justice should be viewed as unlawful. That view was then endorsed by Sir Rupert Jackson shortly after his appointment as a judge of the Court of Appeal of England and Wales in 2008, when he was tasked with reviewing civil litigation costs. He firmly endorsed third-party funding in his reports, recommending self-regulation. He recommended the legalisation of what's called damages-based agreements for lawyers, but doesn't seem to have thought that this term would have any relevance to third-party litigation funding agreements. And under that self-regulation approach, responsible funders have, for example, signed up to the Code of the Association of Litigation Funders, such that it's been said in the courts, in a case, for example, called Akhmedova and Akhmedov, that litigation funding practiced by a funder adhering to the Code of Conduct has been endorsed by the senior courts in robust terms. And the UK, in this regard, has been something of a world leader, blazing a path where others are following. And indeed, the buoyancy and competitiveness of the litigation funding market in this jurisdiction means that funders are starting to look abroad for other opportunities where perhaps there's less competition and more novel opportunities. But in other jurisdictions, the litigation funding market and regime tends to be less advanced. The EU Commission is only now undertaking a slow process of consulting on EU-wide legislation to regulate third-party funding, in respect of which one can say broadly they're positive, but want to keep it within defined boundaries. As I understand it, the most recent position is that that's on hold pending a survey of the third-party funding landscape in the EU, in respect of which they're likely to find mixed results. My understanding is that maintenance and champity are only now in the process of being abolished in Ireland, and then only for arbitration, with litigation coming next. And other jurisdictions such as the Netherlands, Germany, Italy are starting, but only starting, to introduce relevant legislation that permits third-party funders to participate in damages awards. So that's the sort of rosy picture that has been painted and might have been painted without any qualification until the Supreme Court decision in PACAR earlier this year. But that's significantly complicated the position. And I've started to introduce the legislative background because the reason why the PACAR problem has arisen is essentially because of an incredibly convoluted series of legislative amendments that have led to what is arguably a wholly unintended result. So let me try and trace it really quickly, see if you can stay with me. I've already mentioned the 1990 Courts and Legal Services Act, which permitted lawyers to enter into CFAs. That was amended by the 1999 Act to introduce a specific section dealing with litigation funding agreements, never brought into force, but if you give this a Google, you'll find that provision on the statute books. Section 58AA was then introduced in 2009, and it specifically addresses damages-based agreements. At that time, it specifically related only to employment matters, and it sets out the following criteria. 1, an agreement is a DBA if it relates to advocacy services, litigation services, or claims management services. That final one is the important one for our purposes. The second criterion is that payment is conditional on receipt of a specified financial benefit. The third is that the amount of the payment is defined by reference to that benefit. And then fourth, even if you've met all of those three criteria, you can still save the agreement from being an unenforceable DBA as long as it complies with formality requirements set out by the statute and also with conditions set out in regulations prescribed by the Lord Chancellor. So I said the first criterion is the important one for our purposes. So Section 58AA incorporates the definition of claims management services set out in the Competition Act 2006. And if you remember, this was a provision that was introduced in 2009. So we're looking back to an earlier statute. And that was amended again and now incorporates the same definition from FSMA 2000 with effect from 2019, but the definition is the same. And that's defined as advice or other services in relation to a claim, including the provision of financial services or assistance. We then saw another amendment in 2013 to remove the restriction that limited this provision only to employment disputes. So we're now talking about any damages-based agreement relating to any dispute, and it applies to all DBAs. Also in 2013, the damages-based agreement regulations were introduced by the Lord Chancellor, replacing earlier regulations. And if this convoluted series of amendments to primary legislation I'm trying to take you through weren't soul-destroying enough, you might like to know that the Court of Appeal observed in relation to the 2013 regulations, in a case called Zuberi and Lex Law, that nobody can pretend these regulations represent the draftsman's finest hour. So we'll come back to how these regulations might apply or not apply to third-party litigation funding later. But the short point for the moment is that before PACCAR, nobody thought they were of relevance to litigation funders at all. And the final piece of the legislative puzzle to understand PACCAR is that there's then a separate provision relevant to damages-based agreements for opt-out collective proceedings, which says that you can't even save those by reference to the statutory formality requirements and the 2013 regulations. A DBA is simply unenforceable in an opt-out collective proceeding altogether. And so PACCAR was an opt-out collective proceedings case arising from the trucks cartel and heard by the Competition Appeal Tribunal. The essential issue which arose was what is meant by claims management services in section 58AA of the 1990 Act. Is this term apt to cover litigation funders? And again, before this case, nobody thought it was. The Competition Appeal Tribunal agreed with that, and the Divisional Court, hearing the appeal by way of judicial review from the CAT, also agreed with that. Their view was that for a service to come within the definition of claims management services, it had to be a service that involved management of the claim. Funders don't manage claims, they fund them and deal with them at arm's length, and so they don't meet that definition. But the majority of the Supreme Court took a different view. The leading judgment was given by Lord Sales, and he looked at the legislative history that I've just sketched out, and he said it's not legitimate to construe that term claims management services by reference to subsequent developments. So even though I would suggest it's tolerably clear that when the amendments were being made in 2013, nobody thought that the result was going to be to prohibit damages-based agreements in the context of litigation funding, the relevant time to consider the meaning of the word claims management services was 2006, when that definition was introduced into legislation for the first time. All of the subsequent developments, Sir Rupert Jackson's support for third-party litigation funding agreements on a percentage basis, the 2013 regulations and so on, cannot be used as aids to construction. And in particular, they thought that Parliament had deliberately provided a wide definition of the concept of claims management services in that earlier legislation so that the Lord Chancellor could regulate them, if he wished, by what's called a scope order. And now litigation funding obviously wasn't covered by a scope order because nobody thought that it was included within that definition. But in principle, the Lord Chancellor could do so, said the Supreme Court, and it's caught by that term nonetheless. So the consequence of that decision of the majority is that litigation funding agreements, which provide for a funder to recover by reference to a percentage of damages, are unenforceable. But the unenforceability problem is likely to extend even further, even to cases where the agreement merely caps the funder's fee by reference to damages obtained. You might think that's a provision that's usually in a client's interest, but it seems to me that a cap still means the amount of the payment is determined by reference to the amount of the financial benefit obtained, which is the wording of the statute. Now, in the Supreme Court, Lady Rose gave a long dissent. In a lengthy judgment, she argued that everything in the scheme of the 1990 Act, all of the available materials, showed that when the amendments were made in 2013, there was no intention to render damages-based litigation funding agreements unenforceable. And as I've suggested, it may very well be that that wasn't the intention, but the majority would say, nonetheless, the statutory definition is clear. So before the Supreme Court hearing took place, this outcome was more or less unexpected. The immediate result, once judgment was handed down, was mostly rather sort of entertaining headlines by law firms who chose to write about this. In the Variety, Supreme Court throws litigation funders under the truck. But there are, of course, longer-term results. And the Association of Litigation Funders had actually intervened in the appeal to try and explain what some of these might be to the Supreme Court. The quote from Lady Rose's dissenting judgment essentially shows that their warning was the sky will fall down. These consequences, said the ALF, will extend to all or most litigation funding agreements that have been agreed since litigation funding began in England and Wales. This would be massively damaging both to the administration of justice in relation to existing cases which involve funding and the future access to justice of parties who would otherwise have employed litigation funding agreements. It would bring to an abrupt end to hundreds of funded claims with potentially catastrophic financial consequences for all involved in the case. So obviously the implications are potentially enormous, but at the hearing it was already quite clear the direction of travel that the majority was going in. And so what that did mean is that litigation funders had some months to get ready before the judgment was handed down by rewriting existing and new agreements in the meantime. And so obviously now that the judgment's come out, most litigation funders have been giving announcements saying, don't worry, we've rewritten all our agreements, it's business as usual. But there are obviously severe problems presented by the judgment for litigation funding. First of all, where amendments haven't been able to be made in time, there are implications for ongoing and even closed cases. The most immediate consequences are for agreements of claims proceeding as CPAs before the CAT, which is the consequence in which PACAR was handed down. Whereas by contrast, in other types of commercial litigation, such as securities litigation, GLOs or whatever, there's no immediate procedural avenue for challenge by defendants, whereas there is before the CAT. The defendants may wish to consider the need for security for costs, to pick up a point that Simon's made. Briefly, in the CPO context, the picture is a little mixed. There are some cases where proposed class representatives have been able to offer alternative arrangements, and the parties have been able to say that the tribunal should assess those on the papers. But in others, it's apparent that class representatives are really struggling to agree compliant LFAs. For example, I understand there was a CMC last week in the Rail Fares Cartel CPO, at which the proposed class representative offered draft agreement and said it was compliant, but hadn't actually concluded it with the funder yet. And for full disclosure, I'm appearing in a hearing next week where, as defendant, we're challenging an LFA that a PCR has entered into and saying that it's not good enough and doesn't meet the criteria set down by PACAR. So watch this space. So that's the difficulties that have been seen immediately in the CPO context. But group litigation, commercial disputes generally will also be heavily affected, I'd suggest. Existing or closed cases may collapse if a client regrets a bad bargain with a funder. I've already seen some articles in the legal press of particularly aggressive clients who are seeking to recover funds already paid under DBAs, which are now known to be unlawful. And of course, future cases can only be brought on the basis of compliant funding agreements. So that gives rise to my final question, which is, what should funders be doing? How can the enforceability of third-party legal funding agreements be saved? And there are, broadly speaking, three possibilities. The first and most obvious one is to make amendments to the agreement to ensure that it's not a DBA. And so a lot of commentaries on PACAR suggest, well, the obvious solution is for funders to enter into agreements which don't provide for them to take a percentage of damages, but rather provide for them to take a multiple of the costs that they have outlaid. And that does, on the face of it, appear to be a possibility based on the definition of DBA. You'll recall that the two relevant criteria were first that there's a DBA where the payment has to be made on receipt of a financial benefit, but also second, where the payment is defined by reference to the amount of that benefit. So there's obviously an argument that the funder should be able to say that if the claimant gets any damages at all, then they should get their multiple. But the Supreme Court's decision doesn't offer any particular comfort in that regard, and counter-arguments do suggest themselves. So I'm not sure there's complete comfort in that regard. And there's also obviously very different commercial considerations applicable to agreements like that as compared with percentage-based agreements. And in particular, because of the problem that I've suggested, that the restriction applies not only to percentage-based agreements, but also to any agreement that simply caps a funder's recovery by reference to the damage obtained. Because that means that a claimant is actually left unable to ensure that the funder's fee is capped by reference to the damages available, and there's a risk that the multiple might exceed the damages that the claimant actually recovers. In the CPO context in particular, it's obviously important for proposed class representatives to try and ensure that a funder's possible recovery is limited to what's called undistributed damages out of the aggregated damages pot that's available in relation to opt-out claims. and it's not immediately obvious to me how that can be achieved in light of PACCAR. And meanwhile, for funders, there's also a problem with the multiple-based approach, because in the case of a high value but risky claim, a funder might be attracted to it if it can take a percentage, but if it can only take a multiple, it's going to be much more difficult for it to calculate what its exposure might be, what a reasonable multiple might be, and so on, and the recovery might seem less worthwhile. So all of these problems, of course, have access to justice implications. Another possibility, in perhaps a longer-term sense, might be funders capitalising law firms and funding claims that way, based on the perception that DBAs and CFAs entered into by law firms carry lower enforcement risks. So that may be a possible way for funders to restructure their businesses going forward. So that's the first option, try not to enter into DBA at all. The second option is, obviously I've mentioned these terribly drafted 2013 regulations. In principle, the scheme of the statute is that you can enter into a DBA which is unenforceable unless you comply with formality requirements and with the regulations. And the problem here is that the 2013 regulations just weren't drafted with litigation funders in mind. They refer to the client and the representative, but more problematically, they refer to costs and expenses, and the drafting assumption is that the representative is incurring costs on an hourly basis. And it really is thinking about lawyers in terms of who is entering into DBAs. And so Lady Rose said in her dissenting judgment at PACCAR in terms, damages-based agreements entered into by litigation funders cannot realistically comply with either the 2010, which is the predecessor regulation, or 2013 DBA regulations, because those regulations are not drafted in a way that applies to their business. And indeed, you've heard the evidence from ALF before the Supreme Court, which is that every single litigation funding agreement won't have complied with the 2013 regulations. So no doubt funders will be considering the 2013 regulations very carefully to see if agreements can be drafted that technically fall within their terms, but obviously there's an unhelpful uncertainty which does create problems. Incidentally, replacement regulations were produced in 2019 by a leading academic and practitioner at the request of the Ministry of Justice, but never implemented. And those regulations had expressly provided that an LFA is not a DBA, sorry. The problem is that now that the Supreme Court has decided the question is a matter of primary legislation in PACCAR, that approach won't work. That leads me to the third and final possibility, after which I will leave you, which is to lobby for legislative change. And there has been some speculation that an amendment could be made by the Digital Markets Competition and Consumers Bill, currently going through Parliament. I would assume that a bill with that title, any amendment might be limited only to the opt-out collective action problem. In any event, that's only speculation. You probably all know that we're late in the parliamentary cycle. There's an election next year. From what I know from speaking to people at the Law Commission and the Civil Service, it's impossible to get anything on the statute. It's impossible to get anything parliamentary time at the moment. So the prospects of primary legislation seem fairly remote. While we're here, as a quick sort of side note, there's also a very unhelpful uncertainty to do with litigation funding and arbitration. So if we ever get some primary legislation on this topic, it would also be good to clarify that. More promising, though, finally, might be an update to those 2013 regulations, which specifically takes into account the position of litigation funders and ensures that it's clear what they need to do in order to enter into enforceable DBAs. Legislative change in secondary legislation might, of course, now also include a scope order regulating funders directly. One would hope responsible funders would welcome that, especially if it is accompanied by a useful update to the 2013 regulations. And I have to say, in the absence of some sort of updating amendment to the 2013 regulations, there does seem a real danger that funders will have to reconsider their approach to funding in England and Wales. I've already alluded at the start to developments internationally which might make other jurisdictions increasingly attractive, and that will have very damaging effects on access to justice in this jurisdiction. So I'd suggest an updating response would be very welcome. Please tell the Lord Chancellor. Thank you very much.
Thank you very much, Simon and Charlotte. Unless anyone has a question on funding and costs, we can move on to our next session, which is jurisdiction. Thanks very much. Someone will just come and help you with your microphone. about time. Don't worry about time. Just do what you're going to do. Just whilst we're getting ready, jurisdiction, we're going to hear from Charles Hollander KC and Zahra Al-Rikabi, both of whom appeared in the Brazilian dam case. And Charles will kick off by updating us on the jurisdiction rules post-Brexit. And then I think Zahra intends to run us through the Brazilian dam case and explore whether that case might have been decided differently in the post-Brexit world with the different rules.
Well, the jurisdiction session got pushed to the end to assist me because I was in the Court of Appeal this morning. But the downside of that is that we've got the graveyard slot. Or I suppose you could look at it as the keynote speakers, depending on how you see it. I want you to cast your mind back to the heady days of 2016, 4 prime ministers ago, and those battle buses telling us about the consequences of a Brexit vote. Now, I can't remember a single one telling us about the likely demise of Brussels recast. And given that that potentially makes class actions a bit harder, and therefore potentially adversely affects consumers, you might have thought the Remainers should have had their own buses with, do you really want Brussels recast to go? And we'll never know whether that would have made a difference to the extra 3%. The effect of Brussels recast was that there wasn't generally discretion. So if you fell within the rules, you could get jurisdiction. Now, so we then had the principle of the anchor defendant. Claimants would identify a party that was amenable to the jurisdiction, sue them, and then add a variety of non-English defendants as proper parties. So you'd identify often a parent or topco within the jurisdiction. People would often allege a duty of care to those affected by the acts or omissions of its foreign subsidiary and use the parent as an anchor defendant to sue foreign subsidiaries. Or another relevant company was sometimes in the jurisdiction and that was used as an anchor defendant. And many of the GLO and class actions which were started on that basis under Brussels recast. Now, and that also had a knock-on effect because when you had non-EU defendants, but some either within the jurisdiction or within the EU, you would get jurisdiction under Brussels recast against your anchor defendant, and there was then an issue of forum non-conveniens or forum conveniens against the other defendants who were outside the EU. But you'd say, well, this is going to happen in this jurisdiction anyway, because we've got one defendant who's here, and therefore on forum conveniens, you've got to take into account the fact there's always going to be an action in this jurisdiction. Now, so that was how it all worked under Brussels recast. And it actually had this effect that even when you were dealing with non-EU defendants and non-Brussels recast issues, the shadow of Brussels recast affected the result in those cases too. What's now happening is because Brussels recast has gone, the court is looking at forum conveniens and forum non-conveniens issues. And they're looking at matters much more in the round. Now, that potentially does make class actions and GLOs quite a lot harder, or at least in some cases it will. One's also got to the point that the court is now looking at is where you have different defendants served at different times. And you have some defendants, for example, served in jurisdictions where it takes a long time to serve people under the Hague Convention. The court is saying on occasion, and I had one of these last week, that, well, we need to hear the forum conveniens arguments against all defendants at the same time, because the ones who haven't yet been served, their position and their arguments may impact the ones who have been served or within the jurisdiction. So it's quite a different regime. It does mean that because Brussels recast has gone, you can't rely on the old case law, and the old case law is often not not much help in looking at the position now. The transition period ended on 31st of December 2020. So we're looking at the position going forward, if you're looking to start a class action now, under forum conveniens rules. So what are the rules now? Well, the Rome 1 and Rome 2 on proper law still apply. That's because they're unilateral, in the sense they're not based on reciprocity. So we've still got those on proper law. But not so Brussels recast, because it only worked on a reciprocity basis, because it applied to EU states. Now, we tried to join, after leaving the EU, the Lugano Convention, which would have had a relatively similar effect to Brussels recast. Well, the good news, in a sense, was we were supported in that by Switzerland, Norway, and Iceland. However, unfortunately, the European Commission did not support UK entry, surprise, surprise. So at present, Brussels and Lugano don't apply. So we're looking at, so the claimant, as I've indicated, under Brussels recast, had pretty well the choice of forum if you could get your anchor defendant. And so what's left now in terms of international conventions or statutes which are relevant to class actions? First of all, there's the 2005 Hague Convention, which largely is only relevant for exclusive jurisdiction clauses. So there'll be a mandatory jurisdiction there in relation to contracting states. There's some issue as to how it operates because we joined in 2015 and then rejoined in 2021 after Brexit, but perhaps that doesn't matter for the time being. So where you have an exclusive jurisdiction clause, which will cover contractual claims in some cases, perhaps prospectus, perhaps website purchases and the like, then you can rely on the Hague Convention. There are statutory provisions in relation to consumer and employment contracts under 15A to 15E of the CJJA 1982. And those replicate for UK consumers and employees the approach under Brussels recast, essentially, where the consumer is domiciled in the UK, you can sue where he's domiciled, irrespective of the domicile of the counterparty. But that will exclude non-UK domiciled claimants from the class if you want to rely upon that. So if you want to bring proceedings on behalf of a class who are domiciled in different jurisdictions, then that you're going to have problems there because the CJJA will apply to some but not all of the class. You may have to find another basis. 15C covers employment contracts. So there you can sue where the employee habitually carries out his work or last did so, irrespective of the domicile of the employer. And there's protection there for UK-based employees. Now, in principle, you can say the residence and the domicile of the claimants shouldn't matter. There are plenty of GLOs or representative actions made in favour of foreign claimants. And I mean, for example, in the British Airways fuel surcharge case, Emerald, the court said the fact the class was both numerous and geographically widely spread was not of itself an objection to a representative action. There was in one of those cases some other objections because it turned out that the 60,000 claimants who had signed had not actually all known about what they were signing in various parts of Asia. And there was a lovely hearing, I remember, when actually the translation of the Chinese document, which they had all signed, was shown to the court, which was very far from an accurate representation of what they were signing up to. But that's but in general, you can do it. However, in competition cases, under 47B of the Competition Act, as amended by the Consumer Rights Act, whilst foreign claimants can participate in collective competition proceedings, the 11B provides that any class member not domiciled in the UK must opt in specifically. So we're now looking at a position where the court is making, save in these sort of cases, which the specific cases, a decision in the round based on the gateways for service out, forum convenience and forum non-convenience. It may be that you can actually take advantage of some sort of anchor defendant, but the court will look at jurisdiction in the round. So when we're considering what are Brexit opportunities, there may be some, but you have to look at it in a rather different way. Thank you.
Thank you, Charles. Good afternoon, everyone. I mean, Charles has already cracked the joke about us having the last slot, so I'll go straight into it. As Charles has highlighted, there's no special jurisdiction rules in relation to class actions. And so we're looking at the standard rules that apply and trying to apply those principles in the context of a class action, which raises some unique considerations, or at least considerations that are much more stark than when only one or two claimants are concerned. And I thought it might be, we thought it would be quite interesting to look at one or two judgments that were issued before Brussels recast was no longer enforceable or applicable in the UK, and just explore really in concrete terms how those cases might look different. So although I had promised to start with Mariana, in fact, I'm going to take a step back and look at Vedanta first. So that's the Supreme Court's judgment in Vedanta before I get to Mariana. And I'm not only addressing the actual outcome in Vedanta, but sort of some of the context and the background. Vedanta was a case in which 1,800 members of poor rural Zambian farming communities brought proceedings in negligence, alleging personal injury, damage to property, and other heads of loss arising from toxic discharges from a Zambian copper mine. The copper mine itself was owned and operated by the second defendant, a Zambian company, KCM, which was an indirect subsidiary of the first defendant, Vedanta Resources PLC, and Vedanta was a UK company. So as Charles was mentioning earlier, what happened in cases like this is that the UK-based company would be sued. It would be sued under Article 4 of Brussels recast, so as of right, and the English courts wouldn't have discretion to decline jurisdiction, regardless of whether they deemed the UK to be the appropriate forum or not. Now, in that case, they tried a creative argument that this was an abuse of EU law, that if you're only suing the anchor defendant in order to force the court to take jurisdiction, then you're abusing EU law. And the Supreme Court rejected that argument, essentially, as bringing forum non-convenience arguments through the back door. So it did accept that the UK courts had no discretion with regards to the anchor defendant, Vedanta. And then in terms of, then that was used essentially as a gateway to sue the Zambia domiciled subsidiary, and the court, in considering the position of forum non-convenience, accepted that there would be proceedings against the anchor defendant in the UK and considered what that meant for the forum non-convenience arguments involving KMC. Lord Briggs put it quite well in that judgment, explaining the predicament, if you like, of the English courts in that context. So I'm just going to read out a passage from the judgment. Following Ozu and Jackson, the English court has one hand tied behind its back. No more can it say that the proceedings against the anchor defendant form convenient grounds. No more can it say, sorry. This is the precise ratio of Ozu and Jackson, and the Court of Justice was fully aware of the difficulties which that conclusion would be likely to cause in the traditional exercise of the English court's forum convenience jurisprudence in such cases. The result is, in a case such as the present, where the English court is persuaded that, whatever happens to the claim against the foreign defendant, the claimers will in fact continue in England against the anchor defendant, the risk of irreconcilable judgments becomes a formidable, often insuperable obstacle to the identification of any jurisdiction other than England as the forum convenience. Thus, not only is one of the court's hands tied behind its back, but the other is, in many cases, effectively paralysed. Now, what's really interesting about Vedanta is that Vedanta, the anchor defendant, gave an undertaking that it would submit to the jurisdiction of the Zambian courts, were the court to decline jurisdiction in relation to KCM. And the Supreme Court was persuaded by this, that this would be an important consideration to take into account. So what we see is that the domestic courts were already looking at ways to get around the fact that the Brussels recast regulation was being used to curtail their discretion where they did have a discretion. Now, again, given that the courts are no longer subject to Brussels recast, one would think that cases like Mariana would be decided very differently under the current rules. And in fact, I went back to read the judgment to see what, if anything, might change. And in fact, I think nothing would change in the outcome of that judgment. Now, for those of you who are not familiar with Mariana and BHP, it's essentially a case that stemmed from the collapse of the Fundo Dam in Brazil, which released 40 million cubic meters of tailings from an iron ore mine, killing 19 people and causing widespread destruction. Now, one of the really interesting features of the case is not only that there were 200,000 claimants of varying situations, so some were very poor claimants who were impacted in very small amounts by the dam, others were municipalities, others were big companies with millions, if not more, at stake. So there was a very wide variety of claimants and interests at stake. There were also a number of ongoing proceedings in Brazil, different stages. There were class actions in Brazil of a very unique type that were not actually issued by the claimants themselves, but by the state, essentially, by a prosecutor. And so one would think that if forum conveniens was the only consideration and Brussels recast wasn't tying the hands of the court, that the court would leap at finding that Brazil was a more appropriate forum. However, the Court of Appeal, in quite a long judgment, 375 paragraphs, went through in very minute detail what the current situation was in Brazil, what remedies were available to the claimants in Brazil, and held that, and was essentially persuaded by the claimants' arguments that the remedies were not sufficiently effective as to make Brazil the more appropriate forum. So in the context of the case, the court did have some discretion, and that is potentially important to point out, although I'll explain why it wasn't completely decisive. But because these claims were brought because of the parallel proceedings being in a non-member state, the court had the discretion under Article 34 to stay the proceedings in England rather than an obligation to stay proceedings. And so it did have some discretion under Brussels recast in a similar way to the way it would under the common law. Now, the way that Article 34 is framed is narrower than forum non-conveniens or the discretion of the court under the common law, but that wasn't sufficient to in fact, change the court's analysis of the facts. At first instance, Mr. Justice Turner was in fact so put off by the complexity of this case that he went as far as to find that that to bring the proceedings in England would constitute an abusive process. So he didn't only accept the jurisdictional applications that were made, he also accepted the defendant's quite stark argument that it would actually constitute an abusive process to bring the proceedings in the UK. But the Court of Appeal showed a much greater confidence in the court's ability to manage class litigation. It described not only GLOs and the availability of GLOs, but other case management powers in the UK, which suggests that the complexity on its own of a class action will not very heavily sway the forum non-conveniens considerations. So that on its own, the fact that the judge, I think, at first instance, Mr. Justice Turner, said that they were manifestly unmanageable, these proceedings would be in England. And the Court of Appeal just dismissed that essentially and said, well, it's far too early at the jurisdictional stage to be making determinations about whether the litigation, once it gets underway, when the parties start cooperating and talking to each other, whether you would find that it is unmanageable. And so essentially it just showed faith in the ability of the English courts to manage litigation, regardless of its size. I read the other day that, in fact, the number of claimants, given that the case has progressed or is proceeding now to trial, the number of claimants has now gone up to 700,000. And the English courts don't appear to have buckled under the pressure of that fact. So the court was really quite dismissive of arguments around unmanageability at the jurisdiction stage and gave them fairly limited weight. In terms of arguments about the existing proceedings in Brazil, again, the contrast between the Court of Appeal's approach and the judge at first instance is that the Court of Appeal went into lots of detail about the nature and the type of proceedings available in Brazil, the downsides of the proceedings, the delay, all of the factors it ran through. It also, despite the fact that this was a significant class action with over 200,000 claimants at that point in time, it considered the different circumstances of different claimants. And so where a narrow number of higher profile, if you like, so higher value claimants wouldn't benefit from the class actions in Brazil, it gave specific consideration to those claimants, despite the fact that there were only 58 of them in comparison to the hundreds of thousands of poorer claimants with smaller claims. And so it demonstrated that the court won't take a high level or broad brush approach, sort of lumping all claimants together and then determining forum convenience, but will rather take a much more detailed look at the position of different claimants and whether some of them would stand to be harmed, essentially, if it were to refuse jurisdiction. And so that combination, really, of giving limited concern to manageability at the stage of jurisdiction, as well as taking a detailed look at what was available in Brazil and its progress, meant that the outcome of the judgment wouldn't be any different if it were considered now. Also, very interestingly, BHP Australia was one of the two defendants, and BHP Australia was sued as of right in the UK, but wasn't impacted by the Brussels recast in that it made an application applying the usual Spiliada principles, asking for a stay. And the Court of Appeal didn't rely on the fact that that the proceedings against BHP England were going to take place in the UK in any event to dismiss the application. It did that essentially as a secondary argument, but it decided that even if you park that for a moment and look at just the position of BHP Australia, that it would refuse the application for a stay. And so again, the fact that Brussels recast has been set aside doesn't take away from the fact that a detailed, fact-specific investigation will take place, and that where the foreign jurisdiction doesn't offer some critical elements necessary, essentially, for effective justice, the English courts will take jurisdiction in class actions, regardless of how difficult they may be to manage. Thank you.
Excellent. Thank you very much. So that brings proceedings to an end for the day. I think for my part, I just really wanted to wrap up by just stepping back and thinking about the policy question which underlies all of this. So it's clear that class actions are very much here, and they're here to stay. And it's clear that there are lots of unanswered questions which the courts will have to grapple with in the years to come. But ultimately, I think this does come down to what the court's attitude will be to class actions. And it's interesting because obviously these actions are only viable with the assistance of litigation funders. But there are two schools of thought. Either the litigation funders are doing a wonderful job of increasing access to justice and ensuring that claims that otherwise wouldn't be brought are being brought. Alternatively, they're bringing these claims entirely to line their own pockets and not really for the benefit of the underlying claimants. And one of the interesting things that we've seen in the competition field is trying to see how the courts are grappling with these competing interests. And we heard, I think, a reference to the decision of Mr. Justice Knowles, a very permissive approach in the Marks and Clark case, saying this is really good, we need to promote access to justice. But I think it remains to be seen whether other courts and other judges take a slightly narrower approach and a bit more sceptical about class actions and litigation funding in the future. So I hope it's been an interesting day, and I hope everyone will join us for a drink downstairs. I'd just like to finish by thanking our speakers for giving up their time, thanking Paul and Pamela of Birt Court who've helped to arrange the event, and thank you to everyone for coming.